We have to look at the overall lay of the statutory scheme in relation to AMA.
Well, which we have placed before you.
Yes.
We have placed before you. We are not questioning anything that happened after that. Only reaffirms the fact the 81 only said that it was a minority institution. Now, whether that was right or wrong is a separate issue.
That's your argument, and that's your point. That look, even if you were to look at the 81 amendment, 81 reinforces what, according to you, is the correct position even before 81.
That's right. So, therefore, you can look at it.
We'll
and if you decide against us, then that question will arise. Because 81 will not change the status, of the minority institution with the declaration that Basha has wrongly decided. Therefore, all this is a red herring.
All right, what more now, Mr. Sibal?
I've been trying to finish, but what can I do,
There's always time out by the judges, so you have to always factor that in. So, how long more now, Mr. Sibal?
Not very long, not very. I'm just, trying to, then I'll finally come on Basha, and that's it. Nothing more than that. So, now the reference. If you're watching,
yes, you want the reference.
Let's read the reference of Justice Gogoi.
In which case?
Sorry, Madam?
The reference order.
Yes.
Is in Allahabad.
In AMU, Madam. AMU versus Naresh Agarwal. And all other connected matters. That's the challenge to the High Court order. Now, kindly see, Madam, in Aziz Basha, the court, it is to our mind quite clear that 30 sub-article 1 postulates that the religious community will have the right to establish and administer educational institutions of their choice, meaning thereby that where a religious minority establishes an educational institution, it will have the right to administer that. An argument has been raised to the effect that even though the religious minority may not have established the institution, it still have a right to administer it if by some process it has been administering the same before the Constitution came into force. We're not prepared to accept this argument, and I'm not arguing it. It's completely wrong, Madam. The article, in our opinion, clearly shows that the minority will have the right to administer an educational institution of their choice, provided they have established them, but not otherwise. The article cannot be read to mean that even if the educational institution has been established by somebody else, any religious minority would have the right to administer it because for some reason or other, it might have been administering it before the Constitution came into force. The words establish and administer in the article must be read conjunctively, and so read it gives the right to the minority to administer an educational institution provided it has been established by it. We're of the opinion that nothing in that case justifies the contention raised on behalf of the petitioners that the minorities would have the right to administer an educational institution even though the institution may not have been established by them. The two words must be read together, and so read the article gives the right to the minority to administer institutions established by it. If the educational institution has not been established, it cannot claim to administer. That's what Basha held, and I agree here. The judgment of the Allahabad High Court, which is under challenge in the present appeal, rejects the prayers made on account of the decision of this court in Basha. The issue arising in Basha, Supra, was referred to a 7-judge bench by an order of this court on 26 November, which is Justice Fazal Ali's order, which is writ petition so-and-so. The aforesaid writ petitions were heard along with other connected matters in TMA Pi by a bench of 11 judges, and the judgment in cases reported in so-and-so. Question which was formulated for answer in TMA Pi, which coincidentally reflects the questions referred to by order of this court of 26 November, passed in writ petition so-and-so. What are the indicia for treating an educational institution a minority educational institution? Would an institution be regarded as a minority educational institution because it was established by persons belonging to a religious and linguistic minority, or it's being administered by persons belonging to a religious or linguistic minority? However, the bench did not answer the question, stating that it will be dealt with by the regular bench. The order of the regular bench passed on 11th March, which for reasons that we need not dilate, did not answer the aforesaid question. The said facts which show that the correctness of Basha arising from the decision in Basha has remained undetermined. That apart, the decision of the court in Yashpal and the amendment of the NC-MEI made in the year 2010 would also require an authoritative pronouncement of the aforesaid question formulated, besides the correctness of the view in the judgment of this court in Basha, which was been extracted above. Ordinarily and in the normal course, the judicial discipline would require the bench to seek a reference of this matter by a 5-judge bench. However, being regard to the background as stated above, when the precise question is already referred to 7 judges and was, however, not answered, we are of the view that the present question set out above should be referred to.
Set out above. What is that?
So clearly, Malaj.
Mr. Sibal, Justice Gogoi has referred to in the referring order, Chief Justice Gogoi's referring order, refers to two aspects.
Yes.
One, the correctness of the decision in Basha has been undetermined, has not been determined.
Correct.
Second, question 3A, which was framed in TMA5,
Right.
was not answered.
That's correct.
So that's why if you will just revisit that once observation there, para 9.
Yes, that's the one.
Para 9.
That's the one. Amendment to the
Para
NCM.
8 actually we'll see
Para
first.
8, Malaj. The said facts which show that the correctness of the question arising from the decision in Basha has remained undetermined.
Now we'll go to para 9.
Then 9. That apart, the decision of this court in Yashpal and the amendment of the NCMEI made in 2004 and made in 2010 would also require authority to pronounce on the aforesaid question formulated as set out above, besides the correctness of the view in Basha. Now, Malaj, my answer to your lordships is very simple. If your lordships decide that Basha was wrongly decided, nothing else arises. Nothing else arises. Yes.
3 questions which Justice Gogoi had in his mind.
Yes.
1, the correctness of the decision in Basha.
Correct.
2, question 3A, which was referred to in item 3A.
Yes.
In fact, he says that 3A covers the correctness of the entire decision, the 261181 order.
Correct. Correct.
And 3, the impact of Yashpal.
Correct. Now, Malaj, as I said to your lordships, and I'm saying it time and again, if you hold that it was established by a minority, then nothing else arises.
23 now.
Sorry?
9 talks of both the things.
No, I know, but I'm on another point. Your lordship is right. I'm not disputing that, Malaj. My request to your lordships is, assuming, Malaj, your lordships finds that Basha is wrongly decided and 1981 is unconstitutional, where does it leave us? It will leave us nowhere. Then we'll still be a minority institution.
You have to rephrase the reference because keeping in para 9 of the order we have just read out.
Yeah.
Yashpal and 2004 Act amendment in 2010 both are required to be examined, and in what context? On the aforesaid question formulated.
Therefore, Malaj, my request to your lordships is you first examine whether Basha is rightly decided or not. Render a judgment there. If you come to the conclusion Basha is wrongly decided, the second question need not be gone into. If you come to the conclusion Basha is rightly decided, then, Malaj, in any case, the 1981 issue will have to be.
Besides the correctness of the view.
Yes.
Besides mean in addition to.
In addition to. Therefore, Malaj, we have to move, Malaj, in a way, Malaj, that in fact it decides the matter one way or the other. Then you can decide the 81 issue. If you decide against me on Basha.
All right. Now what remains now, Mr. Sibal?
NCMEI Act. Amendment to the NCMEI Act would require an authority. The amendment.
On the question formulated.
Yes. No, Malaj, this is not the NCMEI Act.
Sibal?
No, Malaj, actually, if you look at 9, Malaj, actually, we're not fully understood the way 9 is formulated. Kindly do read it 9 again. That apart, the decision of this court in Yashpal. Now, Yashpal dealt with bogus universities in one building. And the amendment to the NCMEI, what was that amendment, Malaj? Originally, university was excluded. Now, university is included. That's all. And how that amendment will impact the question formulated.
Mr. Sibal, also we have to bear in mind, I mean, with a little bit of experience, that when you refer a matter, you're not looking at the matter threadbare. Sometimes you are. Suppose we were to refer it to a bench of 9. Now we have heard it for the last. So we are now completely in season of all
the matter.
No, but what we are saying is normally, otherwise when you make a reference, you refer on the basis of, without really much ado, without going into a very detailed consideration of the matter. Therefore, the words of a referring court never bind the court to which it is referred. Because you are a larger bench, you have to reformulate the questions to bring finality to the dispute. Insofar, but at the same time, there are some parameters which you keep in mind.
Of course.
Which is, you can't go beyond the pleading. You are answering basically a question of law.
That's correct. That's all that I'm saying. But even this amendment, it says to the, would also require an authority on the aforesaid question formulated. What is the aforesaid question formulated? Whether Basha is rightly decided or not. All you want relates only to Basha.
But Mr. Sibal, equally, just as you are saying, don't freeze Basha in point of time. Look at the law laid down by our court before Basha and after Basha. Because rightly, you've also relied on Stephens and, TMA5.
No, that's just a declaration of the law from the beginning.
Likewise, we can't freeze our version of whether Basha is correctly decided without reference to the entirety of the statutory history governing AMU. But we can't say we'll freeze it as of the statutes as in existence one day before Basha was decided.
That's
That
not,
cannot be a,
no.
that cannot be a correct approach for
The point is, Malad, the 1920. So, Malad, let me quickly now finish with this, Malad.
Yes.
Now, having said that, Malad, kindly now see what Basha decided. So we know we've done well. Now, Malad, what are the correct statements in Basha? Kindly look at factual aspect, Malad, so that I don't waste your lordship's time. Kindly come to page 9 of volume 3A. Yes. It says, kindly see placetum A and B, statement of fact. Further, it seems that the existing MAO college was made the basis of the university and was made over to the authorities established by the 1920 Act for the administration of the university, along with properties and funds attached to the college, the major part of which had been contributed by Muslims through though some contributions were made by other communities. This is a factual statement, Mullahs? Correct. Nothing wrong with that statement. It only shows what? That we are the ones who set up the university. And Mullahs, that 30 lakh today, if translated today, into 2006, as translated, it would be 280 crores. And today it'd be 500 crores. So, Mullahs, Basha accepts is the MAO college was in existence. It was made the basis of the university. And Mullahs, the properties and the funds attached, that means everything in the college was handed over to the university. And the section itself says so. So the genesis of it is correct. That Basha affirms. Now, Mullahs, so it was, now number 2 is come to page 14 now. I'm just, Mullahs, indicating the facts that are accepted by Basha itself. It says, that brings us to the end of section 19, sections of 1920 Act. Your Lordship has, sorry, it's not there. Page 14. Yes, kindly. The next paragraph between B and C, Mullahs, sentence starting, the annexure to the 1920 Act. Your Lordship has that?